Hey everybody, welcome. So this is, I don't know, this is our fourth live review now. So we are doing unit 3 and 4. So again, just want to say thank you guys for being here today. So it is Sunday afternoon, 4 p.m. Eastern time. We are a day and a half away from the AP exam. So we got about 44 hours or so if you're on the East Coast. So it's getting close. I know it's that time when the stress starts to elevate and all of that. So again, we'll review everything. I will do my best to kind of look at the chat as much as possible, answer questions. So if you right now, if you're going to just introduce yourself, let us know where you're from. So what part of the country you're from, what city, what state, if you want to do that, or school, whatever you want to do, feel free to introduce yourself to everybody. We'll be in the chat. Hopefully you guys play nicely with each other. Let's be positive, encourage. Because again, I know despite the stress, that's a normal thing, but you guys are going to do amazing on this exam, trust me. So this is unit 3. It is about civil liberties and civil rights. This is without a doubt my favorite unit of AP Gov. We're going to do unit 3 and then we'll do unit 4. Unit 4 is a very short unit, so we'll probably spend maybe 15 minutes or so at the end on unit 4. So like I said, I want to help out in any way that I possibly can, so you guys just kind of let me know. Lisa has seen me more than her family this week. So I hope it's helping. That's all I can say. I am doing great. Thank you very much for asking. Warriors, Rockets. I mean, all I can say is hopefully it'll be the Rockets, I guess. But all right, we got, hey, there's Addison at West Point. Very nice, man. Good looking. How you doing? I hope everything is going well for you. That's a former real life student right there, back from West Broward High School. All right, so let's get right into it. Again, just a reminder, if as always with YouTube, if you want to help me out and you want to smash that like button, that's always appreciated. I am on TikTok now, so if you want to follow me there, at Carey Lamanna, so just like you see it spelled on your screen, CareyLamanna, all together, one, at Carey Lamanna. I have some good things there on TikTok for exam review. If you just basically go through, I've done a countdown from the last 35 days where it has like little kind of note sheets. Just like little cheat sheets. So feel free, definitely appreciate if you wanted to follow there, and you could like and share stuff there as well. That always appreciated. And then you see the little ticker down below. It's telling you about the ultimate exam or ultimate review packet. There's also the ultimate exam slayer. I'll probably talk about those a couple times. I don't want to, get to that too much. So let's jump right in. Civil liberties. All right. So one of the biggest things that I want to say up front is make sure that we know the difference between civil liberties and civil rights. So obviously you have a definition. It's a pretty short, quick, succinct one here, but you have civil liberties on the screen. So maybe in the chat, if you're going to let me know, what are civil rights? Because these terms are absolutely not interchangeable. And it is a huge pet peeve of mine. It drives me crazy, especially when AP Gov students use them interchangeably. But people in real life use them interchangeably as well, and they are not the same thing. So first of all, you have on the screen civil liberties, right? So it says guarantees of personal individual freedoms. So these are things that every individual person has a right to do, right? So you have the right, we think about the First Amendment, freedom of speech, of assembly, of press, religion, right? Petition for redress of grievances. Second Amendment, right to bear arms. Fourth and the Third and Fourth Amendment are things you have a right to be free from. So you have your property, right? And police can't just search it. Soldiers can't just come into your house, like these sorts of things, right? You get into jury trial rights, rights when you are accused of a crime, self-incrimination, all these things, right? So these belong to every individual. And one of the key things is that when you think about each of these, they are absolutely restricting governmental power. And so I want to just pop up the next slide. I still will come back to civil rights, don't worry. The Bill of Rights, which is where we find a lot of our civil liberties, restrict the federal government. And so the federal, on purpose there, we'll discuss that also coming up. That's, again, another major part of this unit, right? But notice that civil liberties are limiting or restricting a government. They're saying that it's something that the government can't do. So if we were to actually read the First Amendment, it does not say all citizens or all Americans or all people have the right to believe what they want with religion, or to say what they want to say with speech, or to publish what they want with press. It doesn't say that at all. Again, I'll ask this to the chat. The first 5 words, how does the First Amendment actually begin? All right, how does the First Amendment begin? Because it does not grant us rights. So I'll give just a couple seconds because I want to say the answer. What the First Amendment starts by saying is it says, Congress shall make no law. All right, Congress shall make no law. So the Bill of Rights is actually limiting government. It does not give us rights. It is saying the government can't take away these rights because a lot of these rights already exist, like our right to religion or speech, etc. So it's saying government, federal government specifically, can't take away those rights. Why am I making such a big deal about that? Well, one, it's important to know that we are talking about protecting civil liberties and individual rights here. So I want you to definitely associate that word individual with civil liberties. And then again, to see how it affects the relationship between people and the government, which is that it limits a government's power because it is pro-freedom for the individual. Now, on the other hand, civil rights, which we're going to come to later on. So the first, big chunk of the unit is mostly civil liberties. But when we get to civil rights, here's what we have. Constitutional protections from discrimination against groups of people. So instead of talking about individuals, with civil rights, we're talking about groups of people. Instead of talking about something that people can do, right? Like people can bear arms or speak their mind or practice their religion, civil liberties, civil rights is saying you have the right to be free from discrimination. Governments don't have the right to discriminate against you. So it is, or state governments, local governments, private businesses, when we start getting into certain laws, right? Schools don't have the right to discriminate against people. So what we're saying here is that now it's a fundamentally different thing, right? We're talking about protecting groups of people from discrimination with civil rights. Civil liberty is saying individual people are allowed to do certain things, right? So hopefully that difference makes sense. I know I spent a little bit more time probably than is necessary on that, but it's hugely important to me. And one last thing about that is with civil rights, we're going to see an expansion of federal power because the federal government is kind of in the position of being the ones who are doing the protecting of groups' civil rights. So if somebody's being discriminated against because of a group characteristic, because of their race, their sex, their gender, sexual orientation, a number of other things, religion, right? If somebody's being discriminated because of one of those group characteristics, the federal government is now in the role of protecting people in that group from that discrimination. So with civil rights, federal government's power is getting stronger, right? They have more to do. With civil liberties, it's saying that there's things that government can't do. So hopefully that kind of makes sense. Again, just kind of glancing at the chat because that was a lot right there. Green bike lane, look at that. Got my Congress shall make no law. Very, very nice. Another shout out to Vicky. We can never shout out Vicky too many times, if you ask me. All right, so very, very nice. See a couple other Congress shall make no law. So very good. Now, coming back to the Bill of Rights. Again, you notice that third word on the screen, right? It restricted the federal government's ability. That's the original version of the Bill of Rights, right? Originally, it just was a limit on the federal government. It didn't do anything to state power. So it said federal government, Congress can't make any law respecting an establishment of religion or abridging somebody's freedom of speech, et cetera, et cetera. But states absolutely could. So again, originally, if the state of Virginia wanted to take away a person's religious freedom, if they wanted to ban a certain religion, if they wanted to say you can't make speech that it goes against the governor, they could do that. They were free to do that. If the state wanted to take away a person's right to bear arms, they could do that. If a state wanted to say you don't have a right to a jury trial, we're going to have a judge try you, they could do that. If the state wanted to punish you in a cruel and unusual way, they could do that. What changed? So again, I'll throw that one to the chat. Either vocab word. So I'll give you a few options. What's the vocab word for what changed? So that why this isn't true anymore. What amendment number? That's another thing we could discuss, and we will discuss. What amendment number is going to lead to this change? And the third thing is what clause in that amendment is going to lead to this change? All right. So again, what's the vocab word that's going to change how the Bill of Rights is interpreted? What's the amendment number that leads to that change? And what's the clause that leads to that change? All right, so we have 166 people on right now, so we're still a little bit small, so hopefully we get some more folks coming in here soon. That would be great, but again, thank you to everybody who is here. I see a lot of due process coming in. I see some selective incorporations, Very nice. I see some 14th Amendments. Some people went for multiple of these. So that is really, really, really great to see, as always. Those of you in the chat, killing it. You guys are doing great. So keep it up. So you're absolutely right. We were talking about incorporation, and we'll get to the selective part in just a moment. But for now, the broader term, just incorporation. This is the interpretation of the 14th Amendment that says that now the Bill of Rights also applies to state governments, to local governments, and it limits their power as well. So again, we kind of move on from the original. It just limits federal government. And this was done in a Supreme Court case called Barron versus Baltimore in 1830-ish, 1833. That's the year 1833. And the Supreme Court reaffirmed, said, no, states can violate the Bill of Rights. They're not restricted by it at all. Then the 14th Amendment comes along. And again, like, how do we get to that? The 14th Amendment, at its most fundamental, is a civil rights amendment, right? But it's also going to now be used to have a major impact on civil liberties. So the 14th Amendment for our class is without a doubt the most important amendment in AP Gov, and it's not close. It is hugely important for us. It's very important in real life also. So how exactly did this happen? Well, again, we have to kind of go back. So we'll do a little bit of history here pretty quick, hopefully. So there is a case called the Dred Scott decision. You guys learned this in APUSH if you've already taken APUSH. If you haven't yet, you'll learn it next year in APUSH or whenever you do take that class. And basically, this is a extremely infamous Supreme Court ruling. Long story short, we're not going to get into the details. But one thing that that ruling said, it said that no person of African ancestry shall ever attain citizenship. All right, that's what it said in that ruling. No person of African ancestry shall ever attain citizenship. Okay, so when we consider that, now you fast forward. So we're in 1857 there. Civil War happens. Slavery is abolished in the 13th Amendment in 1865. And then the question becomes, what is the legal status of all the people who formerly had been enslaved? Couldn't be citizens, but weren't slaves anymore. So in this very tenuous situation. So the 14th Amendment is ratified, and it says that basically all persons born or naturalized in the United States, subject to the jurisdiction thereof, are citizens of the United States. So it establishes birthright citizenship, and this is known as the Citizenship Clause. Now, the thing is, the framers of the 14th Amendment were very, very well aware that, especially Southern states, they weren't going to go along with this willingly, right? And so they, first of all, they made them ratify the 14th Amendment to get back into the Union. That was something they had to do. So as a condition to get back into the Union, they had to ratify the 14th Amendment. And it does a couple of interesting things. It specifically limits the power of state governments. It says that states can't infringe on anybody's life, liberty, or property without due process of law. And it also says, nor deny to any person within its jurisdiction the equal protection of the law. So we have these two clauses, the due process clause and the equal protection clause. And equal protection is going to be used for civil rights legislation. So we'll come back to that one later. But this one, when it says, nor shall any state deprive any person of life, liberty, or property without due process of law, it didn't say incorporation. It didn't say selective incorporation. It didn't say Bill of Rights. But the Supreme Court, starting in 1925, so we're going to fast forward 60 years from this, essentially 58 years. And when we get to 1925, the state of New York had arrested somebody for distributing pamphlets that were promoting a communist socialist agenda. And they arrest the guy for his communist propaganda. And he argues that his free speech rights are violated. But remember, up until this point, states were not restricted by the Bill of Rights. So states didn't have to respect a First Amendment right. So if New York wanted to say, yeah, but not here, New York was free to do that until this case in 1925. What happens is the Supreme Court looks back at the due process clause in the 14th Amendment, and it squints really hard. And it says, you know what? It says, nor shall any state deprive any person of life, liberty, or property without due process of law. Well, if a state can deprive you of your liberty, your free speech, then they're depriving you of your liberty. So they can't do that. And so what they do here is they establish for the first time this idea of selective incorporation, which is that now on a case-by-case basis, they're going to hear a challenge and somebody's going to say, you know what, this is a fundamental right, a fundamental civil liberty. and the Supreme Court will review that case. And if they determine that it is a fundamental civil liberty, like in that phrase, life, liberty, or property, then they will restrict the states and say that the state is not allowed to restrict that freedom anymore. So again, it's a little bit complicated. I know that's a really deep dive into this stuff. I hope that you are able to, that made sense. Because in my opinion, I want you to understand. We could just focus on like memorizing flashcards or something like that. But I think, it's important to understand these things as much as possible. And this is something that you definitely might be asked to write about. And so the more comfortable you are with incorporation, the better, because it is the surest bet of anything in all of AP Gov to be on the AP exam. Incorporation will 100% be there. So I think that's time well spent. All right. So then, I got some people talking about Schenck versus U.S. We're actually not talking about Schenck versus U.S. in that. That's a 1919 case. It is actually Gitlow versus New York is the first incorporation case. It's very, very similar. They both involved, one was the Charles Schenck of the Socialist Party. This other one was, it doesn't matter, but communist. But they're extremely similar cases, and the court ruled in opposite directions on them. So that's a whole other story, though. Again, if we were together all year, it's the kind of thing I would definitely torture my students with to try to make them appreciate these stories. So then we get into the amendments now a little bit more. We have the Establishment Clause. So remember, freedom of religion is not going to be an acceptable answer in AP Gov once you know that there is both the Establishment Clause and the Free Exercise Clause. So Establishment Clause, there can be no official religion, no preferential treatment for certain religions. That could either be good or bad. So you can't like punish people or like ban one religion. You can't promote one. You can't help or harm. Basically, the idea is that the government should be neutral religiously. Now, some people in some of the chats, especially like a Unit 3 review video, those of you who have been taught well, you might have heard about a case, a recent one about 2 years ago, Kennedy, that has definitely, the Supreme Court is ruling differently on Establishment Clause stuff than they used to. So our case with the Establishment Clause for AP Gov is Engel versus Vitale. Would the court rule the same way today? I'm not sure. And that's a great question and a good thing for discussion and all of that. But for us, for AP Gov, Engel versus Vitale, it's what you have written there. State-sponsored public school prayer violates the Establishment Clause. So remember, for your required cases, we need to know a few things about them. We need to know the facts, we need to know the holding, and we need to know the reasoning. And the reasoning refers to what in the Constitution did the court use, the majority of the court, use to affirm their ruling, to support their decision. So the facts, remember, that's talking about the background. So we will do this for each of the cases. We have, I think, 9 required cases in this unit. So Unit 3 is all about the cases. It's all the scenario stuff. It's why this isn't a unit to memorize. It's not like a vocab unit. It's an understanding and applying unit, which some people will love. Some people get frustrated with that. I love it. I think it's the best one. I think it's the most interesting one. I hope that you come out of this class understanding your rights a little bit better. I think that would be a huge win for everybody. So the facts is that the state of New York, again, we're back to New York again, they had a policy where they essentially established a non-denominational prayer to be recited at the beginning of the school day. So just like most schools will do the Pledge of Allegiance at the beginning of the day, they would do the pledge and then they would do their prayer. And there was this basic non-denominational prayer. The Supreme Court is going to strike that down and say, nope, that is violating this the Establishment Clause because it is promoting religion. So public school, remember, public school means that it is run by a government. It's typically state and local governments, usually local school boards, counties, cities, that kind of thing. And this is a government that is now promoting religion, and so that's not allowed. The other part of religion that's in the First Amendment is the Free Exercise Clause. So this is your ability to practice or not practice the religion of your choice. So the government can't force you to believe something. They can't force you to say a certain prayer, to pray, or to go to a certain, they can't do any of that. And if you are practicing your religion, and again, it's neutral, we're not talking about you violating laws, like you're not murdering people or something like that, but you have a right to practice your religion. If it's a legitimate religion with like, real true beliefs that are closely held, all that kind of stuff, you have that right. So this is, again, we're talking about protecting people's rights. Our court case for this one is Wisconsin versus Yoder. The facts of this one is that you had Amish families in the state of Wisconsin. They didn't want to send their kids to high school. So they would send their children to, elementary school, middle school, K through 8. But then they felt, you know what, the stuff that's going to be promoted in high school, first of all, they're going to see some stuff that does not reflect our moral values, our religious values. It also isn't preparing them for the way of life that they're going to lead as a person of that faith and that lifestyle. And so basically they said, we're not going to send our kids to public school for high school. This was in violation of a Wisconsin law that said it was mandatory or compulsory to attend public school until the age of 16. The Supreme Court is going to rule in favor of the Amish families, and they're going to say compelling the Amish to attend public schools beyond 8th grade violates the free exercise clause. And so they rule in their favor. And so this is a victory for freedom of religion, specifically free exercise. It kind of kicks the door open to homeschooling and all that kind of stuff. All right, so just glancing, because that's our religion stuff. So as we get ready to transition over to speech, again, welcome to everybody else. We got some new ones in here. We're at 209 right now, 213. So I like to see that. Lauren Schroeder asks, didn't the court get rid of the lemon test? Yes, they did. They did that in that Kennedy case. So the Kennedy one is the one I mentioned a minute ago, Kennedy versus Bremerton. And it was the football coach who kneeled at midfield to say a prayer after a game. Again, we can't get into all those details right now, but you're right. They did get rid of the lemon test. It's interesting though, and this is part of like stare decisis. We talked about that yesterday when we reviewed Unit 2. The court did not get rid of all of the lemon test cases. So they specifically said that going forward, they aren't going to use the lemon test anymore to determine if something violates the Establishment Clause, but that all the previous cases are still like legitimate case law. So it is interesting. And so, yeah, I guess you're right. That could affect the separation between church and state. Okay. Oh my gosh. I'm going to skip right over that one. Ms. Smith. Yeah. All right. Ms. Bales. Okay. We'll come back. We'll do shout outs and all that stuff later. So let's do free speech. All right. So freedom of speech. This should be like the thing that everybody agrees on, right? That people should have the ability and the right to speak their mind, that you should be free from not having to worry about getting arrested or the government censoring you, that kind of thing. This is viewed most often as the most fundamental of our rights and liberties. Again, when we talk about incorporation and Gitlow versus New York, where the court established this idea of incorporation, it was in a free speech case. It is essentially the court views it as the most important of our freedoms, as the cornerstone for everything else. So if we don't have free speech, we don't have freedom. So what you're going to see, typically speaking, and we obviously have a huge exception. You can, if you want to put it in the chat right now, what's the exception to what I'm about to say? But the Supreme Court usually rules in favor of free speech over and over. And it's the liberals on the court rule in favor of free speech. The conservatives on the court rule in favor of free speech. The occasional libertarian-ish leaning judges rule in favor of free speech, which obviously they would. That should be the most obvious. But pretty much everybody rules in favor of free speech. We do have a case, one of our required ones, that goes the other way. But by and large, they're going to rule in favor of free speech. Now, you have here the limit, which this is probably not the best place to start. So let's go here. And I see a lot of you putting up clear and present danger, clear and present danger, clear and present danger. There we go. I like Cubing Pro says Shank versus US, Ava Shank, Amelia Shank, appreciate it. That's what I was looking for, Shank, but you are all right. And you can see the clear and present danger phrase there. So this, again, facts of the case. You have Charles Shank. He is among the Socialist Party, and he is distributing leaflets that are opposed to the military draft, right? And so he's saying, resist the draft. The draft is unconstitutional. It is violating your 13th Amendment right to be free from involuntary servitude. It turns out the federal government, not huge fans of that argument. They're like, hey, we're trying to fight a war. It's World War I here. And so they rule, this is, again, it does happen. And most often when they rule against free speech, it's usually in wartime. That seems to be a recurring theme through US history, is that we have all these freedoms and then it's wartime and we start to chip away at those freedoms. Now, the Constitution does not say anything like that, right? It does not say you have free speech this much during peacetime, but only this much during wartime. It doesn't say that. But the argument is the Supreme Court's like, oh, we're in a crisis. You know, we need to unite. We need to give the government more power, do what the president says, do what Congress says. So for better or worse, that's how that typically goes. So he gets arrested. The Supreme Court is going to rule against him, and they are going to uphold a law called the Espionage Act. The Espionage Act, passed by Congress, made it illegal to basically try to discourage military recruitment, to harm the morale of the troops. And so you have this really interesting, and even the court mentioned in its ruling, usually what you were doing would be allowed. They said, like, in normal times, this would be allowed. However, they said that phrase, that speech that creates a clear and present danger can be restricted. Now, a couple things. And again, I'm at risk of going into too much detail here, but I think it's important. We are not under the clear and present danger test today. So there's a part of me that it drives a little bit crazy that this is one of our required cases, because it is not current case law, at least this part. We are not under a clear and present danger test anymore. The court got rid of that by Gitlow. They already got rid of that. So it did not last even more than 5 or 6 years. Today, this first one, this is the limit on speech today. So what the court asks is not, does speech create a clear and present danger? Again, they haven't asked that for 100 years. What they ask today is the speech intended to and likely to incite imminent lawless action? Is the speech intended to and likely to incite imminent lawless action? And if the answer to those questions is yes, somebody's intending to incite imminent lawless action, imminent meaning it's about to happen now, lawless meaning illegal, right? Action, somebody doing something. So is it likely that because of somebody's speech, people are going to break the law very, very soon? And if the answer is yes, then that speech can be restricted. If the answer is no, then they're allowed to say it. So people are allowed to say all kinds of wild things that are kind of threats, like in the abstract, where they're not threatening a single person or an institution or a school or something like that. They can say down with the government. But if there isn't like a specific plan, if they're not like actively doing something, they can say that. I see a couple people putting Brandenburg in the chat, and you guys are exactly right. This is from Brandenburg versus Ohio. It is a 1969 case. It is not a required case, so you do not need to know it by name. So those of you who do, that's awesome. It's definitely one that I teach my students. I like them to know. But yeah, that is exactly the case. My guess for why that's not the required one is that the backstory is about the KKK. And I feel like College Board thought that that was a little too... They just didn't want to have a case that was about the KKK. I'm guessing. I don't know. I could be wrong about that. But otherwise, it does seem weird to me that we teach Schenck instead of Brandenburg, because Brandenburg is the current one. So coming back, though, to Schenck versus U.S., and some of you guys put this in the chat as well, and it's a really important thing to keep in mind, is that last part. And this part is still relevant today, which is that the court here is showing that there can be time, place, and manner restrictions on speech, meaning that speech that is normally allowed, and so it's not the content of the speech that's the problem, but it's saying not at this time, not over here in this specific area, place, not in the way in which you're delivering the speech. So classic example of time, place, and manner restriction might be like noise ordinances. So yes, you can have the freedom and have a party and you can play loud music, but a lot of places say, yeah, but you can't play loud music after 10 p.m., right? That's a time restriction. You can play loud music at 2 p.m., but not at 10 p.m. or 12 a.m. or something like that, right? If you want to have a march and you want to assemble, and so you want to have a protest, the city cannot refuse you the right to protest because they don't like your message. Be like, oh, well, you're pro-life or pro-choice, or you're pro this or that, or we don't like this side. You need to be patriotic and for the president. You're not allowed to protest against the president, or you're not allowed to protest against the war. They can't say no for any of those reasons. But they can say, well, you're not allowed to do that protest on this major road at 5 p.m. during rush hour. Instead, you can do it Saturday morning from 8 a.m. to 12 p.m. or something like that. So they have to provide you with an alternative method of producing your speech. They can also say things like, all right, you can't do it within 50 yards of a funeral or something like that. And again, some of you might get the case that I'm referencing there. So there can be restrictions, but please be aware with time, place, and manner restrictions, it's not about the content of the speech. So those restrictions are allowed. It's just kind of saying not exactly the way you wanted to do it, but we're going to give you this other way to express yourself. And so the Supreme Court does allow for these time, place, and manner restrictions. All right. Very nice. Charles Hopkins. Very nice. That case is called Snyder versus Phelps. If anybody wants to be very upset, you can read about that. The Westboro Baptist Church and Snyder versus Phelps. Again, I would hope that in a I hope that you've learned about that in class already, because it's tough. But thank you for the dirty. It's not dirty money. Appreciate it. Oh man, that was amazing. Okay, so we have a couple other types of speech, but so thanks. Symbolic speech and hate speech are protected. Symbolic speech, we're just talking about nonverbal. So it could be your t-shirt that might have some kind of message. It can be, a flag, or burning a flag is a form of symbolic speech. Obviously, some people aren't going to like that very much, but you are allowed to express yourself, right? Non-verbally. Hate speech is also protected. Again, it can't cross that line of inciting imminent lawless action, but people can say hateful things, and that is not a violation of their speech rights. Or they are allowed to do that through their free speech. I might have worded that kind of poorly. Types of speech that are not protected. The AP exam loves to ask this, and they're trying to trick you into saying that hate speech is not protected. Okay, we can all look down on hate speech. I'm sure that we do. That's a good thing, and you might even combat their hate speech with telling them other things about why they're wrong, or not engaging them, or whatever. But libel, slander, obscenity, fighting words are not protected. You might see the term defamation, so I could have put that here too. Defamation is kind of a broader term. Libel and slander are specifics. So defamation is when you're doing something to harm another person's reputation. You are lying about them, right? You do not have a right to lie about a person. So somebody wants to defame someone, you can sue them and you can win that case. Libel is when it is a written lie, so something that's published, like a newspaper kind of thing. Slander is a spoken lie. And so, again, these are not protected. Now, it is extremely difficult to win a defamation or libel slander case because, again, pretty much everything in the U.S. we lean towards, if there has to be something imperfect, we're going to let you have more freedom when it comes to speech and press. And so that's something to be aware of because, again, the preferred outcome for the Supreme Court is to rule in favor of free speech pretty much whenever possible. Again, the main exception is going to be in a wartime like that. Now, Tinker versus Des Moines. I see somebody, Pink said black armband. So there we go. Tinker versus Des Moines, classic case. You have students that were protesting the Vietnam War. It was a peaceful, silent protest. They just wore black armbands to school. It had a peace sign, black armband. That was their way of quietly protesting against the Vietnam War back in 1965. The school finds out. They say, you can't do that. They do it anyway. If you don't take off the armband, you're going to get suspended. And Mary Beth, Tinker, and a couple others, they said, all right, suspend us. And so they got suspended, and we have this case, and it's going to be a massive victory for speech, a massive victory for students' rights. What you have there, and again, I do want to emphasize this. Sometimes people look at this outcome and think that it's a restriction on speech. So let me be very clear. This is not a restriction on speech. This is a pro-free speech outcome. The reason that some people will say would think that is because, well, you can read what it says on the screen, right? It says students have free speech at school that can only be limited if it substantially interferes with the operation of the school. So the phrase that the Supreme Court said was the discipline and operation of the school. So if I asked you, do you have free speech at school? The 234 people that are on here right now, I'm guessing that many of you from your experience of being if you're in public school, you might be like, I don't feel like I have free speech at school. And I get it. I've been in school. So I was a student for 13 years in public school, and then I've taught for 14 or 15 years now. I get it. Do you have as much free speech in public school as you do outside of school? No, you don't. Your speech is more limited there than it is elsewhere. Teachers' speech is more limited in public school than it is outside of public school, right? So those things are true. Despite that, though, it's important to know that before Tinker versus Des Moines, the view was that students did not have free speech at school at all. If the teacher told you to not say something, the teacher was right and you were wrong. And that is fundamentally upended with this case in Tinker versus Des Moines, right? It says that students don't shed their constitutional rights at the schoolhouse gate. So you have free speech. So hopefully we're good on that. But this is absolutely a pro-free speech decision, for sure. And again, you have the fact that they also say that symbolic speech is pure speech. So you get, a little bit of that as well. All right, our next case is New York Times versus US. So again, very, very closely related. Now we're talking about freedom of the press. Basically, everything we said for speech goes for press. They're going to rule in favor of freedom of the press as well. Your facts of this case, this is where Daniel Ellsberg, he leaked a lot of Defense Department documents. They are known as the Pentagon Papers, is what those are referred to as. So he took these documents and he gave them to the Washington Post and the New York Times. And basically what these documents did was they showed that things that had been happening under the Nixon administration, under the Johnson administration, and even Kennedy administrations, going back basically 10 years, said, you know what? Things that they've been telling the public about the Vietnam War are very different than what was true. And so he exposes these lies, right? Now, the Nixon administration doesn't want this published. So they say, hey, this guy stole this. They can't publish this stuff. They try to block publication of these papers. The Supreme Court is going to rule in favor of the New York Times and Washington Post, in our case, New York Times versus the US. And you have a very wordy explanation here, right? So I understand the wording here. It's like, but I wanted to use what the court said because I think it's important to get this right. There is a heavy presumption against the constitutional validity of governmental claims of prior restraint. Okay, heavy presumption means that if there is a prior restraint, okay, actually, let's start with prior restraint. Prior restraint means censorship, all right? That's the fancy word for censorship before the fact. So if the government here, they're trying to prevent something from being published before it gets published, that's prior restraint. What the court's saying is, if they want to claim that they can do that they can censor you ahead of time, when we come to hear this case, we are biased. The court is telling us that they are biased. If you look, it says there's a heavy presumption against prior restraint, meaning imagine that. So I'm making this up, but I think it makes sense, hopefully. All right, so imagine the way the Supreme Court decides a case is that they add up points, right? And the first side of the case, so it's either the government or the New York Times, whoever gets 100 points first, they win the case, all right? Like, that's not how it's really done, but for this illustration, I think it works. All right, so 100 points, whoever gets 100 first wins the case. What this sentence means is when we start the case, it's not 0-0. When we start the case, it's 99-0. The New York Times is ahead by 99 points. So they will almost always win. Now, is it possible the government could get 100 points in a row and win that case? Yes. Is it likely? No. So you have to be careful. Again, I like accuracy a lot. So they did not ban prior restraint or censorship. They didn't say it's impossible. What they are telling you, though, is it's going to be really, really difficult, and that they are very biased against prior restraint, and that they want to rule in favor of free speech and freedom of the press. All right. So I hope that makes sense. I'm going to take a sip of water. I'm going to glance at the chat real quick. I've seen a few things. Better Call Saul is a great show. Not number one. My number one show is Lost. It is the greatest thing ever on TV. Bump. All right. I had seen somebody asking, but I didn't see the exact question. Somebody was asking about I think strict scrutiny and stuff, but I'll wait and see if I find that again. Lauren says, "Did you know that the court allowed prior restraint in schools? We learned about it in class." Oh, okay. That wasn't so much a question for me. Yeah, I think that's why I saw somebody put Hazelwood, right? So that's the Hazel. There it is. Ben knew that one. Very nice. Hazelwood versus Kohlmeyer. Yeah, that's the school newspaper case. Very nice. Shout out to Ms. Loopker and Ms. Smith. All right. My shirt is Bob's Burgers. It's a famous, I don't know, famous, but it's a scene in Bob's Burgers. Tina is trying to drive in a parking lot, and yeah, hilarity ensues. Okay. There's Lauren's question. Real quick, I'll try to do this one fast. Can you explain rational basis, strict scrutiny, and whatever the third one was? The third one is intermediate scrutiny, so it's right in the middle. It's, it makes sense. Lauren, ask me, like, do you really want me to? So I'll tell you, it's probably not on the AP exam. Like, it surely isn't vocab you need. So I might come back to that. I think it's, again, important. It's basically levels of judicial review. So the Supreme Court takes some of our freedoms more seriously than others, which is weird. I guess I can say that really fast, which is with strict scrutiny. If they hear a case of strict scrutiny, the most likely outcome is that they're going to strike down the law and rule in favor of the individual. If they hear a case with rational basis, then it's really easy. The government just has to prove that there could be a reason why they could make such a law. So they will almost always rule in favor of the government and against the individual right or freedom. And intermediate is an in-between one. So if, for example, anything that involves race is going to be at a strict scrutiny level. Anything involving speech is strict scrutiny. Anything that's regulating the economy is rational basis. And so you have where governments can't really make many laws about religion, race, or speech, because those will likely get struck down. Gender is typically been an intermediate. Age has been an intermediate. And so it's a lot easier to make laws about age or race or sex, not race, age or sex. And then rational basis is, like I said, it's usually like economic things, and those pretty much always are allowed. Yeah. All right. Shout out to Mr. Rob, who has a good student like Lauren, who asks good, deep questions. So appreciate it. Must be a good teacher there. All right. And Mr. Truong, which I think is that Ben, who was just answering stuff. So is that a teacher that's in the chat helping me out, telling everybody Hazelwood versus Kohlmeyer? If so, appreciate it. Love to have some teachers in here. If you are a teacher in here, you can always feel free to let us know too. Again, thank you to everybody who's here right now, 243 of you. If you are looking for practice, for study guides, for things about how to write the FRQs, check out the Ultimate Review Packet, the Ultimate Exam Slayer. That stuff is great. Otherwise, I got the content for you here on YouTube. And we'll be back together, don't forget, tomorrow at 6 and 8 p.m. So 6 p.m. we're going to do Unit 5 tomorrow. And at 8 p.m. tomorrow, we're going to do FRQs. And that is going to be a big one. Maybe hopefully a little bit celebratory as everybody starts to feel confident and ready to go out right at that last minute. Wow. Shout out to Tifa. Thank you, Brandon. That one goes back. I recognize the SpongeBob avatar. So he's been around for a few chats, or a few live streams, I should say, in the past. All right. So now we're going to shift away from the First Amendment. We're going to head over to the Fourth Amendment. Again, love the First Amendment, love the Fourth Amendment. No unreasonable searches and seizures. That word unreasonable, you can see that word is going to lead to controversy, right? What's a reasonable versus what's an unreasonable search? People are going to disagree. Obviously, law enforcement is going to want to be able to have more freedom to conduct searches. People who are like more civil libertarians that are more worried about the rights of the accused are going to be very much about the Fourth Amendment. You can see the three things that make a search legal by a police officer. They don't need all of them. They need at least one of them. And if they get one, they're good. Probable cause, a search warrant, or consent. So police officers, they don't have to tell you the truth. If they want to search and you say no, and then they say, you have to, I'm an officer, and you say, oh, okay, I guess you have to search, you've consented. It is up to you. The Supreme Court has said it's on you to know your rights. They don't have to tell them to you. Now we'll get to where they do have to tell them, but that's only when you're getting arrested, right? With Miranda. So we'll get to that in a moment. But yeah, that's pretty much it. There is something known as the exclusionary rule, which there it is. Okay, right there. We have the exclusionary rule. Oops, get that back on the screen. If a search is conducted illegally and they find evidence against you, they cannot use that evidence against you in a trial. Now, it's important to point out they can use other evidence. So this does not mean necessarily that you automatically go free. So it's not a case of, oh, that one piece of evidence they found illegally, they didn't, whatever, they didn't have a warrant for that. But everything else, we know we think you did it because we have all this other evidence. They can still put you on trial. They just can't use that piece of evidence. Now, is it possible that that was the best piece of evidence and that without that piece of evidence, their whole case collapses? Yeah, that's possible. And that happens sometimes. So that's going to lead to controversy, right? Where some people feel like the exclusionary rule lets people get away with crimes on technicalities. Proponents of it say, yeah, but if we didn't have this rule, then the Fourth Amendment is just words on paper and it wouldn't actually be protecting us, right? Because the Fourth Amendment says that you are not supposed to be subjected to unreasonable searches and seizures. And it outlines what makes a search reasonable or legal. And so this is going to be enforcing essentially that Fourth Amendment and letting that, actually protect people's rights. Now, in the last couple of years, so this is just in the last 2 years, I think, since they redid AP Gov just a little bit. It was just a minor overhaul. But one of the things that they did was in the course, they made a distinction between two kinds of due process, procedural due process and substantive due process. The word procedural is going to do a lot of the heavy lifting for us here. So you can see on the screen, we have a definition. It says it requires government officials. Oof, this is a very wordy, I don't like this definition. This is pretty much straight from College Board, so it's like, let's do it. Requires government officials to use non-arbitrary methods when making and enforcing decisions over constitutionally protected rights. Okay, let's keep this really simple. It's talking about the procedure, all right? So you have a Fourth Amendment right. You have Fifth Amendment rights that protect you against self-incrimination or double jeopardy, all these kinds of things. Procedural due process is referring to the procedure. It is the actual process from the moment that you are suspected of some kind of crime until the moment when you are punished. You have rights along the way. And procedural due process is making sure that those rights aren't being violated. All right. Man, look at Kason over here. All right, you guys distracted me. Much appreciated. Okay, so with procedural, we're thinking about the Fourth Amendment. We're thinking about the Fifth Amendment. We're thinking about the Sixth Amendment. The right you have the trial by jury, right? The right that all these different things, a speeding a public trial. It can't be secretive, right? They can't search you without a warrant. All of that stuff, that's all procedural. So it's a very broad term. We're essentially thinking of our Fourth through our Eighth Amendment rights are going to fall under that umbrella of procedural due process. With that, kind of mentioned this a moment ago, we do have the Miranda rule. So this is about the Fifth and the Sixth Amendment. So it doesn't actually establish any new right or freedom for people. What it does do, though, is it says that the police have to inform you when you're being arrested, right? So if you're being arrested, they have to tell you, by the way, you have the right to remain silent. You have the right to an attorney. If you can't afford an attorney, one will be provided for you, blah, 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 right? So they have to tell you those rights. And if they don't tell you those rights, and then you were to confess, then that confession could be thrown out of court and they wouldn't be able to use that against you again because of the exclusionary rule. Pink asks if you need to know the Miranda rule. Yes. Do you need to know the words? No, you need to know what it is. So yeah, about exactly what it says, what I just said. Now there is an exception, and we do need to know this also. So the court, basically in the 1960s, you had very liberal court rulings that were very much protecting the rights of the accused, like in Mapp versus Ohio, exclusionary rule, like in Miranda versus Arizona, Gideon versus Wainwright, all these cases. Then as you get into the 70s, 80s, and 90s, and even more recently, the court has become more and more conservative over time. And so it starts narrowing these rulings, right? And so one of the narrowing of the Miranda rights is through the public safety exception, which is if there's some kind of situation happening and the police are arresting somebody and they ask that person a question because it's in the middle of a dangerous situation and they haven't given that person the Miranda rights. So the officer asks the person that they're arresting a question, the person answers the question, and the person was not informed of their Miranda rights to remain silent, et cetera, et cetera. That evidence can be used against them in trial. And like it says there, it's a public safety exception. So this case, essentially, the idea is imagine that they are chasing a suspect. He has a gun through through a supermarket. I forget, not everybody has Publix's. Shout out to Publix. Anybody want a pub sub after this? And so they chase the person, they tackle the guy, they pat him down and he doesn't have the gun. And they're like, where's the gun? Because, well, they're in a supermarket, right? A 3-year-old might pick up the gun. It's a dangerous situation. And so if the guy says, like, points over there and he says it's on the cereal aisle or whatever, I don't know, they would be allowed to use that evidence against them in a trial. All right. One time for Ava. She knows about Publix. She knows what's up. All right. Yeah. Oye is awesome. So Oye. I think it's Oye, right? But that is a great website, even though I don't apparently know how to say it. Shout out to Mr. Robertson. All right. And Mr. Glazer. Gideon, a required case. Florida man walks into a bar. Long story short, he gets arrested, right, for allegedly breaking into a pool hall, stealing some coins. And when he gets to trial, he asks for the court to appoint an attorney for him because he was a homeless person. He did not have money, couldn't afford an attorney. And the state of Florida says no. State of Florida says we only provide attorneys if it's a capital case. This is not a capital case. It's a felony, but it's not a capital case, so we are not going to give you an attorney. And so he gets convicted. He does the classic. This is why it's a movie. It's called Gideon's Trumpet if you want to watch it. But he learns about the law while he's in prison, and he writes to the Supreme Court a handwritten appeal. They end up hearing his case. They rule in his favor, and they say that states must provide an attorney for people in felony cases. You can see there, this is an incorporation case, right? So previously, the Sixth Amendment said that the federal government had to provide you with an attorney. Now, Gideon versus Wainwright, states have to also, okay? All of this is part of the liberty versus security debate, which is kind of your main big picture. Like if you want a big picture unit 3 into like one debate, it's probably that, liberty versus security. So again, most people aren't on one side or the other. Most people want a balance. So on one extreme, you could have complete liberty and freedom, but you wouldn't have any safety, right? Or you could be in a police state and have total safety and security, but have no freedom. And probably to most of you, neither of those sound like very good ideas. So most people want both liberty and security. The thing is, there's a trade-off, right? So the more freedom that you want to have, you might end up with a little bit less security. The more security you want, you're definitely going to be giving away some liberty, right? And so that's where you have these debates over, well, what's the right balance of liberty versus security? Yeah, so that's, and you have some examples there. So you have modern examples. We don't need to know details about this stuff really. Warrantless searches of phones aren't allowed. Bulk collection of cell phone metadata, again, not without a warrant. Government surveillance, things like the Patriot Act. So you get into some of these more very controversial things. And so it's important to at least kind of be a little bit familiar with those. I just saw a question, Vodka Drunkinsky, so welcome back to Vodka. What due process related vocab do we need to know? Kind of going through that right now. Realignment, delignment, that will be unit 5. So come back tomorrow at 6 p.m. The original Florida man. Yep, good to see. I saw somebody asking, substance due process. Who asked it? It's gone. That's all right. It's our very next vocab term. So again, let's just keep going. Tamara asks, what's the Patriot Act? Whew. There's a lot to unpack there. That is a post 9/11 law. It's called the USA Patriot Act. It's actually yelling at you in all caps, USA Patriot Act. I feel it's an acronym, but it actually is in all caps like that. But yeah, it was a law that allowed for a lot more government surveillance, in the name of fighting terrorism. And so I think that's all I'll say. It's been replaced by the USA Freedom Act, which is a little bit more toned down, but it's similar. Okay. Roe versus Wade, we're going to come to in just a moment. So I'll talk about that. I'll answer that question momentarily. Substantive due process. So I did see some people asked about what substantive due process, because I did procedural before. Substantive is very, very different, and I actually don't love what I have written on the screen. I would rewrite this a little bit more detail. fundamental rights that cannot be arbitrarily abridged. So in both of them, you see the word arbitrary. When something is arbitrary, it's not based on law. It's based on like what a person says or decides. So nothing about our due process is supposed to be arbitrary. Like everybody is supposed to have the same due process, whether we're talking procedural or we're talking substantive. All right. Now, the real thing about substantive due process, it goes a little bit beyond what's written on the screen. This is when the Supreme Court kind of squints and they're like, you know what? There are other protected rights, other fundamental rights that people have that are not part of the Bill of Rights. And governments can't take those away either. That's substantive due process. So it's a way for the court to discover that there are other due process rights, other rights that are not specifically listed. So if you can't tell, substantive due process is going to be controversial. So there are members of the current US Supreme Court that say substantive due process does not exist. So I'll just go back to that. So we have members of the court right now. There's no such thing as substantive due process. There are others. The more common critique of it is not that it doesn't exist, but that the court goes too far with it and that it's kind of judicial activism. So yeah, substantive due process, it's going to be controversial. They're essentially discovering other rights that are not found in the Bill of Rights. Now, the thing about that is, how could they do that? And actually, let me go back to this screen one more time before I jump ahead and get into privacy and Roe versus Wade. I see you guys talking about Roe versus Wade and all that. What's happening here is we have the Ninth Amendment, right? And I could have asked that as a question for the chat. I probably should have. Anybody want to put in the chat real quick, what kind of rights does the Ninth Amendment protect? All right, that's my question for the chat. We have 244 people on right now. What kind of rights does the Ninth Amendment protect? I was trying really hard not to say the word. I almost said it. What kind of rights does the Ninth Amendment protect? Bump, bump, bump. Roe versus Wade, Lauren, we will talk about next, I promise, not ignoring. They are unenumerated rights of the people. So you guys are saying it, ones that aren't listed explicitly, ones that aren't enumerated. That's exactly right. The Ninth Amendment, it essentially says that just because the first 8 amendments listed speech and press and bearing arms and no unreasonable searches and jury trials and double jeopardy and cruel and unusual punishment, just because it listed all those, that should not be taken to mean that there aren't also other fundamental rights that we have. And it's just a reminder that there are other rights, right? And so when the court wants to discover a new right, there's essentially 2 ways that they can do it. One is they can just say, oh, this is what the Ninth Amendment was talking about. The other way is they can go and say, we're using substantive due process to establish a right. Okay, so hopefully that makes sense. I don't think you need to know more than this. I've probably told you more than you need to know, honestly, about substantive due process, so don't stress it too much. But that's the idea, is that it is a way for the court to create, discover, establish new rights that governments can't infringe, just like they can't infringe on your rights that are found in the Bill of Rights. The biggest example of this is going to be privacy. All right, so privacy, not in the Bill of Rights. But the Supreme Court, essentially, again, there's 2 ways that you can argue that there's a right to privacy. One is use the Ninth Amendment and squint and say, hey, this is one of those, because you know what? The First Amendment, the Third Amendment, the Fourth Amendment, the Fifth Amendment, the Ninth Amendment, all together, we can kind of, if we dump all those amendments into a pot, we stir it up, we can kind of see that there's a right of privacy. The other way is just to say substantive due process. We are establishing that privacy is a fundamental right and governments can't take it away. Now, some of you might wonder, and again, seeing in the chat, I know a lot of you aren't going to wonder this, you already know. But what's so controversial about that, right? Because people, generally speaking, people like privacy. The reason that this is so controversial is that privacy was used as the basis for abortion rights. So when we talk about Roe versus Wade, which again, people have been mentioning, so Lauren just popped it up again in the chat. I know you're getting to it, but I just want to ask, is Roe still required? Because some people are saying it's mid, but I thought it still was. It is not required. Roe versus, so it's a little bit confusing though, okay? It is not required in the same way that the other 14 required cases are required, all right? Your 14 required cases, you have to know the facts, the holding, and the reasoning. However, there are 3 cases that are listed by name in the CED in this section: Griswold versus Connecticut, Roe versus Wade, and Dobbs versus Jackson's Women's Health. You do need to know these 3 cases by name. All you need to know is the ruling. So all you need to know for Griswold versus Connecticut is that it established the right to privacy, okay? You don't need to know more than that. If you do know more than that, that's fine. So that was a case about birth control and contraception and all that. You don't need to know the facts. You don't need to know the reasoning. You need to know that it established that there is a right of privacy. Roe versus Wade, you do still need to know that this case said states can't ban abortion. Or conversely, you could also say that it established that a woman has a right to an abortion. Okay, so yes, you do need to know it. You don't need to know it to the same level as Wisconsin versus Yoder and Gideon versus Wainwright and McDonald versus Chicago and all the rest. So I hope that makes sense. View these 3 cases as vocab words. All right. So the exact same way that you should know the word substantive due process, because it could be tested. That's the level that you should know Gideon versus Wainwright. I'm sorry, not Gideon. Griswold versus Connecticut, Roe versus Wade, and Dobbs versus Jackson Women's Health Organization. All right. Shout out to Mr. Hayward. Lauren, let me know if that makes sense, because what I'm saying is true, I promise. So yes, you do need to know them to that extent. I hope that makes sense to everybody. So again, Roe versus Wade says, yes, there is an abortion right. It's based on the right of privacy. It is a substantive due process right. In 2022, the opposite. Dobbs versus Jackson's Women's Health, it says there is not a substantive due process right to an abortion. And what that means is it's not constitutionally protected. So states not only can regulate and restrict it, but states can outright ban it if they want to. So this is, again, a massive shift in policy. We're now 3 years away from this case. So we're to the point where I would expect to see this on the AP exam this year. I think that we're ready for this to be back on the AP exam. It kind of took a break for a couple of years because when you have a major case like that happen, usually the AP exam kind of is about 1.5 years, 2 years in advance. So you won't get things that are like super, super recent. So the AP exam might not know that Trump got reelected again, that sort of thing. I would expect to see abortion back on the AP exam this year because it's been a couple of years. And obviously that is a, huge, huge thing. Charles is inviting everybody to Heimler's review. If you go to that, I'm just saying you should spam the chat a little bit and be like, yo, come give them links to me and be like, you need to check out Lamanna's videos. He has unit 3, 4, and 5 up on YouTube for free. So everybody can check those out that, only can see his first 2 unit review videos. If you want to tell him, hey, I wouldn't be mad at you. Again, just kind of looking because I do want to see reactions to these last 3 cases to make sure that everybody's with me. Shout out to Mr. Hayward and Mr. Grant. I low-key think my lives are better. I'll say that. I know he's the YouTube king, and I got nothing but love and respect. But it's a little bit, we only have 241 people, so it's a little bit easier to interact with the chat and that kind of thing, for sure. Lauren asks, what was Dobbs versus Jackson? Maybe she said that before I said it, because I think we kind of just did that one, right? So it was, again, an abortion case where the state of Mississippi, right? They actually didn't ban abortion. They did a 15-week ban. But anyway, that's getting into details that you don't need. Vodka Drinkinski asks about strict versus loose construction. We kind of did that a little bit yesterday. Oh, no, she's answering. Okay, awesome. I just realized I'm assuming that Vodka Drinkinski is a girl. I don't know why I assume that. Shout out to Mrs. Schwartz at Lake Mary High School. Okay. All right. Thanks, Ava. Appreciate you. All right, Mrs. Bales, Mr. Gold, Mr. Clay. All right, love it. Hey, I appreciate you. Somebody with an unpronounceable AE name. I love to be the reason you have a 95. I'm sure you're really the reason. I mean, honestly, that's actually the truth, is that you're the reason, but I appreciate the kind words. All right, very nice. McDonald versus Chicago. This is our last civil liberties case. It is a gun case. So the facts of it is that the city of Chicago had an effective handgun ban. They did not actually ban handguns. What they did do, though, was they said you have to get your handgun licensed, otherwise it's illegal. And then every time, 100% of the time that somebody would say, hey, I have a handgun, I want to get a license for it, they would deny the permit or the license. So effectively, they banned handguns in Chicago. The Supreme Court in this case, McDonald versus Chicago, is going to strike down that ban, and they incorporate the right to bear arms. This, again, should remind you, incorporation is a case-by-case ongoing thing. The entire Bill of Rights has not yet been fully incorporated. It just about is, but almost everything is, but not literally everything. And the Second Amendment, you think about how huge the Second Amendment is, only 15 years ago. So most of you guys were alive at a time when your state could have banned the right to bear arms. 2010, they can no longer do that because it now is constitutionally protected, not just from the federal, but from the states as well. Charles, yep, DC versus Heller. You don't really need to know that one by name, but you are right about that. Very nice. All right. Okay. And moving on to civil rights, we're going to go through this kind of quick. Oh, man, it's already 5 o'clock. Oh, all right. So we are a little over an hour right now. I have been explaining a little bit too thoroughly, you might say. Civil rights, we are protecting groups from discrimination. We already said that. Black codes, probably not going to be on the AP exam. You might have done that in APUSH. So you have these laws right after the Civil War that were making it crimes to essentially try to re-enslave people, really nasty stuff. Jim Crow law is much more likely to be on the AP exam. So we're talking about laws that legalized segregation. So these were at the state and the local level. And so what these did, you're thinking about things post-Plessy versus Ferguson that allowed white schools and black schools, white water fountain, black water fountain, restaurants that would serve only whites and would tell black people they had to go around back or things like that. So these are Jim Crow laws, again, legalized segregation, and they lasted into the 1960s. Before we get to what ended that, we have obstacles to vote. So the 15th Amendment says that race cannot be a barrier to voting. So now black men technically gain the right to vote, but then aren't really able to exercise that. So yeah, you have all these things, these loopholes that the states found. They got creative to try to make sure that even though black people were allowed to vote, they weren't able to actually vote. I saw Ashritha, so I don't know if you already hopped off, but if you're there, what's up, Ashritha? Huge help to me in past years, all-time great student, again, actually in real life student right there. You have things like the literacy tests and white primaries that were used, again, to prevent black voters from voting successfully. Intimidation, threats at polling places, grandfather clauses, all of this. So you have our voting rights amendments. This is a little bit in the third unit. It's also in the fifth unit, so I'll just kind of hit it real quick right here. 15th Amendment, race can't be a barrier to voting. 19th Amendment is that sex can't be a barrier to voting, so women's suffrage. And then the 26th Amendment says that age can't be a barrier to voting once you are 18 years old. So 18 and up. Now, if a state wants to allow even younger people to vote, they are allowed to do that. It's not saying that you have to be 18 to vote. It's saying that if you're 18, they can't stop you from voting because of your age anymore. And then you have the 24th Amendment is going to ban poll taxes. All right, so that's going to be a huge monumental one. And it goes along with the Voting Rights Act of 1965. So 24th Amendment, we're in 1964, bans poll taxes. So again, that does mean you had 100 years of states successfully preventing black voters from successfully exercising their right to franchise, their right to vote. Poll taxes, banning poll taxes is going to get rid of one huge obstacle, and then the Voting Rights Act gets rid of the other major obstacle, which were literacy tests. Now, it does get into some other things as well. This stuff is what you need to know for Shaw versus Reno. So I don't think I'm going to go into these details very much right here, right now. But yeah, we'll kind of come back to that in Unit 5. All right, so remind me, we'll get to that tomorrow in our 6 p.m. live stream. All right, social movements. So you have another way to influence policy. Again, we'll talk about this in Unit 5 as well, kind of contrasting social movements with interest groups. Social movements are going to, they're more grassroots, like from the people themselves kind of rising up and demanding change. So when we think about like Letter from Birmingham Jail, we think about the civil rights movement of the 1960s. We can think about more modern or current stuff like the LGBTQ rights movements. These are all social movements. Black Lives Matter, social movement, right? And you have people coming together trying to get change done. There are pros and cons to social movements. The fact that they represent large amounts of people, they get people active and, into things and trying to affect change can make them powerful. At the same time, the fact that they often lack leadership, it might be too difficult to know like what exactly are they trying to get done. That can limit their effectiveness at times. One of the things that the AP exam likes to focus on here is going to be successes of social movements and how they have successfully at times made policy changes. So we have here, again, the Civil Rights Movement. We just did 2 of these. We did the 24th Amendment and the Voting Rights Act. Again, by the way, these major landmark civil rights legislation will be on your AP exam. In fact, I'm going to predict that question number 1 on multiple choice, I know there's multiple versions, so it's going to be right for somebody, I hope. Number 1 on multiple choice on Tuesday is going to be related to this right here. It's going to be the Voting Rights Act. And you are going to sit down, you're going to open up, it's going to be the laptop this year, or the computer, whatever. You're going to click that. And number 1, you're going to see Voting Rights Act, and you are going to go like this. You're going to look over and you're going to see the other person by you that also is watching Lamana live streams. And you guys are going to be like, oh, we got this. We're cooking for sure. So I know that's going to happen. So just remember when it happens, when you get that nice, easy Voting Rights Act question, think about me. Think about this moment. Hey, when you're writing FRQs, if at the end of your FRQ, you just want to be like, this has been a LaMoney production, go ahead and do that too. That'll be a nice way for me to, see you when I'm scoring an FRQ, be like, hey, this is somebody that was in the chat probably watching these videos. I know they know what they're doing. We got this. Collab with Jacob Clifford and do a macro live stream. That's not a bad idea. That is my guy. So I'm always right here. Jacob, you watching? We'll do a live stream together. We'll do some econ. Love, love, love my macro. All right. So the Civil Rights Act. This is the most significant civil rights legislation in U.S. history. I just realized, do I not have Brown versus Board anywhere? I don't appear to have a slide for Brown versus Board. So let's just hide this real quick and let's do Brown versus Board because that's an oversight. Brown versus Board, 1954. This is Lego Batman. I actually already did about 4 or 5 years ago. Fun fact. Okay, so with Brown versus Board, the facts of the case, you have where students were not allowed to attend certain public schools because of their race, right? That's kind of the polite way to say it. The honest way to say it is that Black students weren't allowed to attend schools that were white only, right? And so this happened all over the country. That's your facts, your background. The Supreme Court is going to rule against that. They're going to strike down these racially segregated schools. So they are going to rule segregated public schools unconstitutional. Be careful on that. It's public, not private. So private school could be theoretically segregated, right? It's public schools. And it did not actually force the integration of schools. It said that segregated schools were unconstitutional. And that there is a difference there. We're at hour 13, so I don't think we have time to get into the difference between desegregation versus active integration. But that should be a clue that one is going to be more active in doing things. In the 70s, we get into more integration, or late 60s, we'll get into integration. At first, it was more desegregation. Anyway, they use the Equal Protection Clause to do that. So it's the Equal Protection Clause in the 14th Amendment is what's going to do that right there. Excuse me. All right, my voice is starting, you do this. It's a lot of words that I'm saying. I think you guys know that. If you want to smash that like button, feel free to smash that like button. We're only at 80 likes right now. Come on. We got to do better than that. So let me ask a little bit more sincerely. If you guys can do me a favor and smash that like button, you do know how much I appreciate it. Thank you guys so much. And thank you for all your support and all the videos and trying to help that algorithm. I feel like students like me a lot. Teachers like me. The algorithm just doesn't know. So it just doesn't show people my stuff. That's my theory anyway. That might be me just protecting my feelings from getting hurt. So that is definitely possible. So this is our most significant piece of civil rights legislation, the Civil Rights Act of 1964. What did it do? It banned discrimination in 2 areas of life. So let's focus on the ending first: public accommodations and employment. What does that mean? All right, employment's easy, right? You can't refuse to hire somebody because of their race. You can't fire somebody because of their race. And not only their race, but like you see there, you have 5 things: race, color, sex, religion, or national origin. So these are what's known as protected classes. So when it comes to employment, you can't fire somebody because of any of those things. Oh, I don't like that religion. Oh, what do they believe? Isn't that a little bit weird? Oh, he's atheist. Can't fire somebody because of that. You can't refuse to hire somebody because of their religion. Public accommodations are a little less obvious. So we're talking about here, because usually the word public means government and private means, non-government. And you see the word public here, so we're thinking government, because remember, we just said that for public schools, right? So schools that are run by a government. That's not what this means. Public accommodations are private businesses that serve the public. So if you have a business that serves the public, it can be a restaurant, it can be a hotel or a motel, it can be pretty much any kind of business you can think of, because guess what a business does? It serves the public. You cannot deny your services based on somebody's race, color, sex, religion, or national origin. 5 protected classes. You can't make your hiring and firing decisions, and you can't refuse service. So I hope that makes sense. You guys let me know in the chat if you have questions about that. Appreciate you guys getting those likes up. Look, we got up to 132, 133. All right. So thank you. I just have to ask. Sometimes I forget. This is part of me being a bad YouTuber sometimes. Bear X Flower found me last night. That's awesome. I'm glad that it's helped so far. MCQ, nice. Awesome. Collab with Mr. Truong. Well, I mean, we were collabing in the chat. I feel like that's kind of what I think happened. Women's rights movement. So again, just come in naming some legislation. You have things like the Equal Pay Act, did exactly what it sounds like, right? Equal pay for equal work for men and women. Civil Rights Act. This is an easy one to forget about because we focus on the Civil Rights Act. A lot of times we focus on the race part, but it also did protect women as well. So it said about sex as well. Whoa, appreciate you, Shane. Look at that. Well, I appreciate it. Thank you, Lily. Affirmative action. Okay, so we have where affirmative action is where you're trying to give preference to groups of people who have been discriminated against historically. And so that happens, since the 1960s. It's been, all right, well, it's not enough to just stop discriminating against people because of their race, their sex, mostly race and sex. We actually have to take positive steps to increase admittances to college and to that sort of thing. Again, thank you guys in the chat. I appreciate you, Shane. It's awesome. But what happens here is, well, I guess all you need to know really is that it's now essentially struck down. I say the word essentially eliminated because, again, technically it's not. This is where strict scrutiny. So Lauren, if you're still there and you remember you're asking about strict scrutiny a little while ago, I think the court says for affirmative action, because it's race distinctions, that you have to look at that through a lens of strict scrutiny. And they essentially said that it will be so difficult for any school to ever prove that it's absolutely necessary for them to use race as one of their factors, and that it's the only way. So strict scrutiny means that you are doing something that is completely unnecessary or totally necessary. There's no other way to do it, and this is the least restrictive way possible to get something done. So you have this compelling government interest. You've got to do it. This is the only way. And the Supreme Court says, yeah, affirmative action is not so compelling anymore. And so they essentially strike it down back in our Harvard case from 2022. So that one is pretty much gone. They are actually looking at now this summer, they're probably going to finish off affirmative action with a case about it for employment. So as far as college admissions go, affirmative action is basically done. For employment, it's probably going to be done. By the time you guys get your AP scores, affirmative action probably won't exist for employment either. Just a prediction. All right. With affirmative, or with the last couple things is we have a colorblind versus a race-conscious interpretation of the 14th Amendment. So again, real quick, and it's why this is such a challenging topic sometimes. Both sides are using the 14th Amendment's Equal Protection Clause for why they're right. Colorblind is what's winning now. So when they strike down affirmative action, that's colorblind. What colorblind means is you can't make any racial distinctions. It does not matter what the intention is. It doesn't matter if you're trying to help minority turnout or minority representation or opportunity. Irrelevant. You cannot make any racial distinctions, no matter whether you're trying to help or harm. Race conscious says you can't make racial distinctions to harm minority groups, but you can make distinctions to help. And that's kind of the traditional from, I would say, from the 60s until about 2000. You had where race conscious was the dominant view. And the last 2 decades, colorblind has taken over and become more of the dominant one. All right. Appreciate the goat talk in the chat as always. Okay. That's all I got for Unit 3. Unit 4, let's see. I actually don't have it like this with the little banner. So what I have to do for this one, I'm going to have to share my screen. And yeah, StreamYard is acting a little bit funky. So unfortunately, I'm going to have to, I think, share my whole screen. Ooh, which I can't do. Why is that not working right now? Ooh. Well, okay, so I don't think I'm going to be able to show you my Unit 4 stuff, which that is less than ideal. All right, so we're going to do this stuff pretty quick. I'm going to do just the most important things from Unit 4. Unit 4 is the least important section on the AP exam. I'm being honest about that. It is the smallest. It is the easiest. Those of you who got the Ultimate Exam Slayer, I broke down exactly how many questions have been on the AP exam from Unit 4, and it's not many. So if you are trying to make good of your time, Unit 4 is the place where you can kind of skimp on and move to other things. All right, just real quick to look in the chat as we transfer from Unit 3 to Unit 4. Again, appreciate the goat chat, goat talk. I barely passed macro. Well, hopefully you did pass it, and hopefully you passed because that you would have passed better. Mr. Beck is the best AP Gov teacher. Huh? Everybody knows that. I mean, who doesn't know that Mr. Beck is the best AP Gov teacher? All right, I bench Cheyenne asks how much I bench. It's only 275. I was getting reps and I felt like I was getting close to getting like some major PR movement, but that life happened and I, wasn't regular at the gym for a few weeks. It moves away. So bench strength, it goes away so fast. Eminent domain, Mickey and Lauren ask, yeah, it is in the Fifth Amendment. Actually, Lauren's not asking, she's helping. Squat 455. So yeah, my bench and squat, my squat and deadlift are respectable. My bench is a little, so yeah, it's 455, 275, and 455. Those are my PRs. Macro live, that would be a good idea. I think Mr. Clifford Jacob is going to help you guys out on all of that stuff. All right. Hard money and soft money we'll do tomorrow. Was I an actual teacher? Yes, I was an actual teacher. We've seen a few people from my actual real life physical classrooms come by. All right, so Unit 4, we're talking about political ideologies and beliefs. Political socialization, going to be on the AP exam. It's going to be the easiest question on the AP exam. Family is the most significant source of political socialization. What we're talking about is how do people acquire their political ideology? So why do you turn out to be libertarian? Your cousin turns out to be conservative. Your sister is liberal or whatever, right? That's what political socialization is. It's how do we obtain our beliefs and ideology. Family is the most important source of it. Social media is obviously becoming hugely important as well. Okay. Ridiculous. Political ideology. So let's talk about the big three for AP Gov. We do conservative, liberal, and libertarian. I'm doing that in alphabetical order, so can't get mad at me for that. Conservatives. Basic idea is that they favor tradition, right? So the way that things happen in the past, so a little bit slower to make changes, traditional values, respecting authority, police, law and order, be safe and secure. So security over liberty, that kind of thing, typically national defense. This is what we think of with conservatives. With liberals, we focus more on change, right? So they are okay with the government having more power than conservatives are typically. They want the government to regulate the economy. They're the ones who are going to be upset a lot of times if people are too rich. They're They're going to, say we should have higher taxes. Nobody needs to be a billionaire, promote equality, that kind of thing. So more government stuff there. Libertarians, freedom. Libertarians are the easy ones. I hope that you get libertarian questions on the AP exam because you only have to think. With conservatives and liberals, you have to think a little bit because conservatives don't want the government involved in the economy, but they want the government to be regulating social things. Liberals are the exact opposite. They want the government to regulate the economy, but they don't want it to regulate your social freedoms. Libertarians don't like the government ever. They want freedom always. So they are super consistent. They are very, very easy. For testing purposes, they should be your favorite for testing purposes because is it giving the government power? Then the libertarians against it. Is it giving individuals more freedom? Then libertarians are for it. It's really, really that simple. Like Lauren says, yeah, libertarians don't want any restrictions. Fancy Tuna asks, difference between libertarians and Republicans in big business. Yeah, really, really simply. Libertarians aren't pro-big business or anti-big business. They are pro-freedom. And so what people do, people can do. So they aren't going to be for like breaking up monopolies or things like that because they're going to say people will break up monopolies themselves. If we think Amazon's too big, then we won't shop at Amazon anymore. And they would point to things like in the past, it used to be Walmart. And before that, it was Sears. Most of you guys might have never even been in Sears. But Sears was bigger in the past than Amazon is today. And so libertarians will point out somebody new will come along, they will compete with Amazon, and they'll defeat Amazon. We'll choose somebody else over Amazon. So libertarians they're not going to do anything to help Amazon, but they're just going to be hands off, laissez-faire, right? Hopefully that makes sense. They want low taxes for everybody. Conservatives are more actively helping those big businesses and that kind of thing, like making regulations to help them to fend off competition and things like that. Again, something that I should point out here, Trump is not a traditional conservative. Trump is not a traditional conservative. So some of the things of how AP Gov describes conservatives, you might notice they don't really match Trump too well. And that means that they don't always match MAGA too well. So conservatives usually are pro-free trade to an extent. Libertarians are completely free trade. Conservatives are more free trade than liberals usually, but Trump's not. And so now we're in this weird place where liberals are the ones that are against tariffs and the ones that are promoting free trade, and the MAGA conservatives are the ones who are against it. So we definitely have some differences. So just be aware of that. I don't know what that's going to mean for the AP exam. Are they going to stop moving away from those traditional conservative questions? Because, yeah, he's not traditional conservative. All right. Workout routine. Push, pull legs, man. Push, pull legs. I did see some people earlier in the chat had mentioned questions about supply side and Keynesian economics. I apologize that's not on the screen right now. Keynesian, that's how you say it. You probably pronounce it as Keynesian or something when you look at it. It's Keynesian, but it's a guy's name, John Maynard Keynes. He was a British economist, pretty much the most significant economist of the 20th century. And so his school of thought is known as Keynesian economics. For our purposes, it's really, really simple. So these aren't going to be tough for you. The question is, what should the government do when we're in a recession? All right, that's how these questions are going to go. What should the government do when we're in a recession? Keynesian economists, they say the government should spend money. That's the answer. Government spend money. Excuse me, I got the hiccups now. We're getting to the end of this. I can't keep talking too much longer. Government should spend money. They'll spend a bunch of money, and that'll give, people have more money to spend. They'll buy more stuff. When they buy more stuff, businesses are going to hire more workers, and then people get more jobs, and the economy will get back on track. So what's the solution to a recession? Recession, I think we know, but recession is when the economy is doing badly. Lots of people are unemployed. Keynesians, government should spend money. Supply side economists, same question. What's the solution? What should the government do when the economy is in a recession? Their answer is the government should cut taxes. It should engage in pro-business policies. And when they cut taxes, now those governments are going to have, those businesses are going to have more money. Because they have more money, they're going to hire more workers. And now those workers are going to have more, they're going to have jobs, they're going to buy stuff. That's going to mean more stuff needs to be produced, and more companies will buy more or hire more workers, and you get the economy working again. They're actually kind of similar in the fact that they both want the government to take action, and both of them think that this will start the cycle of getting the economy back on track. Libertarians are the free marketers, and they disagree. They say, what should the government do in a recession? And their answer is nothing. The economy will self-correct in the long run. Those of you, I know there's a few of you in macro over here. Those of you in macro, you already know they're right in the long run, right? The economy will self-correct. It will get back on track. The question is, but how long is that going to take? Is it a matter of months? Then maybe it's best to do nothing. But what if it's a matter of years and years or even longer? And so that's where, typically speaking, Keynesian economics is more associated with Democrats. Supply side is more associated with Republican. And then the libertarians are just going to be mad at whatever they do because they're going to do those policies. I won't mention that. I go through that, how both parties in all actuality are kind of both supply side and Keynesian, but yeah, don't worry about that. For AP Gov, Keynesians are more Democrat, supply side are more Republican. And that will, work what you need. Keynesian at FDR, it's a good example of that. I've been going to the gym for a while. Okay. Next up, last couple of things. All right, so I kind of just hinted towards that. We have liberal and conservative. So, okay, a couple of things. Remember that ideology and parties are not the same thing. So an ideology is a consistent set of political beliefs. It's your beliefs about how big the government should be, how strong or weak should it be, what areas of our lives should government be involved in. That's what an ideology is. A party is a group of people trying to win power. That's what we'll talk about tomorrow at 6 p.m., Unit 5. So come back for me for that live. Check out the unit review video between now and then so you can have good questions if you need some clarification on things. But yeah, parties are trying to win elections. Democrats, as a party, are typically more liberal. So that's the ideology that goes with that party. And Republicans are more conservative. Libertarians, they don't really have a home. There is a libertarian party, but a lot of libertarians aren't very happy with it very much. And that party doesn't win. So you kind of have where they can affect libertarians socially, agree more with Democrats. Economically, they agree more with Republicans. And so they end up trying to decide how to vote based on what's more important to them, right? Is it the economic issues? Is it the social issues? A lot of times in this country, there's a little bit more of a home for libertarians in the Republican Party. Traditionally, you kind of see that with Elon Musk has a bit of a libertarian streak when it's convenient for him. He's also very okay with the government doing things to help his businesses. So that's not, particularly libertarian, but that's how that goes sometimes. You guys good in the chat? I feel like some people are crashing out. I don't know what's happening. Lauren says trickle down and trickle up for supply and Keynesian. That is one way to say it, because yeah, it's Keynesian is give people money, right? It's sometimes likened to dumping money out of a helicopter. Again, you might get that if you are in macro. Okay. Last couple of things. We're almost there. Monetary policy. So I mentioned this yesterday in the Unit 2 video. So now here, monetary policy is done by the Federal Reserve. We're talking about money supply and interest rates. And if we're being more accurate these days, we don't even really need to focus on the money supply anymore because the Fed has decided we don't care about the money supply. We just care about interest rates. So to keep it really, really simple, again, those of you who follow current events, you might be aware that Trump has been talking a lot about interest rates. If anybody wants to put in the chat, what does Trump want to do to interest rates? Does he want interest rates to go up or to go down? Does he want them higher or lower? So in the chat, what does Trump want? Higher interest rates or lower interest rates? The answer, though, and I'll let you guys answer that, it's not a presidential power. It's not fiscal policy. It's not Congress and the president. It is the Federal Reserve. They are an independent regulatory commission. President can't fire the head of the Federal Reserve. He can't remove them from power. They are independent, and we want them making monetary policy independent of politics so that they don't ruin the value of the dollar. Like their job is to make sure that the value of money, that we have moderate inflation, price stability is what they call that, and that we have low unemployment. That's their goal, is that we have low unemployment and that we have low inflation. A lot of you guys are saying up. It's actually not true. Oh, I keep coming back to Lauren. I don't know. I keep seeing that. But yeah, she's right. He wants lower interest rates. And the reason is, what you do need to know for AP Gov is, when should the Fed do higher interest rates and when should they do lower interest rates? So it's similar to your Keynesian and your supply side economics. Slightly different question though. If we have high inflation, what should the Fed do to interest rates? So problem, high inflation. Prices are going up too much, right? High inflation, they should raise interest rates. That's why interest rates are high right now, because we have high inflation. So the Fed has done the right policy. Finally, they might have been too slow getting there, and that's a whole other thing, again, more for a macro video. But when you have high inflation, the answer is raise interest rates. When you raise interest rates, guess what people do? We borrow less. When we borrow less, we buy less. So how do most people buy a car? How do most people buy a house? We borrow money. But when the interest rate goes up, it's too expensive now to borrow money for that car or for that house. And so guess what we do? We don't buy that new house, that new car. And so the point is, when stuff is getting too expensive, the Federal Reserve actually wants people to buy less. Now, politicians don't like that, because when people buy less, guess what we feel? We feel poorer. So Trump wants lower interest rates. And that's pretty standard, by the way. That's not really a Trump thing. That's a politician thing. Democrats, Republicans, to be fair, that's a pretty standard thing. They like low interest rates. When should the Fed do low interest rates? The answer to that is when unemployment is high. Okay, so if we have high unemployment, people are out of work, to get the economy going again, they should lower interest rates. So then people will borrow more and they'll spend more money. So this comes back to that same idea as before of get the economy going by getting people buying stuff. All right, so hopefully that makes sense. Low interest rates, people will buy more, borrow more, and buy more stuff. So you do that to fight unemployment. High interest rates you use so that people will buy less stuff, so you can get inflation under control. All right, I hope that makes sense. Okay, it does not seem like the chat is really talking about that too much. Whoa, Think with a Portal is talking about currency appreciation. I love it. Trump wants to depreciate the currency, though. Fun thing to keep in mind. So that, again, a whole other thing. Sir, this might not be an exam, but if people are saying that Trump is going to cause a recession, why is he increasing interest rates? He is, okay. That's a complicated question for AP Gov. He doesn't want to increase interest rates. And that's a whole other thing of why does he want lower interest rates? Part of it is also to counteract the things that he's doing that are raising interest rates. But that's, I think, beyond the scope of what we are talking about here. The very last thing that we're going to talk about is public opinion polls. Random sample, make sure everybody has an equal chance of being selected for your poll. Stratified, that you look at the demographics and make sure that it's like kind of in proportion to the group size. Sampling error is that you didn't ask everybody in the population. So there is a % of your results that could be due to chance variation. And so you got to be cautious when you get the results of a poll. Don't take the word of any one single poll. But again, when you look at lots of polls, you can get a relatively decent idea of things. In fact, sometimes these days we tend to be maybe a little bit too harsh on polls. The polls didn't do that bad of a job in 2020. I'm sorry, why did I say 2000? They weren't too bad in 2020. They also weren't too bad this year. They're not great. They're imperfect for sure, but that's, yeah. All right. I think that is everything I wanted to hit on from Unit 3 and Unit 4. There are 250 of you here right now. So again, I just want to say thank you so much for you being here today, spending part of your Sunday afternoon with me. If you haven't already, you want to smash that like button, you want to do that, thank you again. Thanks to those of you, Shane in the chat, doing some nice work over here, and anybody else. If you do need some review materials beyond what I have on YouTube, so I have, again, the whole course is up for free on YouTube. You have note sheets that are up for free. But check out the Ultimate Review Packet if you need some more help with like study guides. You want to get into like the content that you might see on FRQs. There's really good practice stuff there. You have 2 practice exams and a ton of practice questions. A lot of those practice questions are lower level, but then you have 2 AP level practice tests. The Ultimate Exam Slayer is amazing for test prep. So it's about the FRQs, how to write them, strategy for those. And it's really about like what to focus on for testing. And then it's practice tests. It's on a digital testing platform that looks exactly like what you're going to see on on Tuesday afternoon. So I can just show you that real quick, maybe. Yeah, so it looks like this. And so you have a test question. Again, they're good test questions. You can X out stuff. You can cross stuff out. You can make your answer choice next. You can also then at the end, when you review your test at the end, you'll get some great feedback. Finish test, yes, submit. I didn't finish this test, obviously, and it's been open for a while. And it'll tell you, hey, here's how you did on the various questions. Here are the right answers. Here's explanations for the right answers. So it has some great stuff with feedback. Tells you how long you took on them. You can set a time for it. So there's great stuff there. So again, if you're interested, feel free to look at those things. I'm sure that stuff would help. So, check it out. If it helps you, that's great. Let people know. Tell your friends. Again, if you're heading over to Heimler's live soon and you want to just tell people in the chat, hey, there's this Lamana guy. Check him out also. He has some stuff available that maybe Heimler doesn't have available that you have to pay for from him. They can come check out my stuff. If you're not already, follow me on TikTok at Carrie Lamana. I appreciate you guys. Tomorrow night, we'll be back together. 6 p.m. we'll do Unit 5. 8 p.m. we'll do FRQs. And that's when we can do all of that kind of prediction stuff. Anything you want in the chat, I'll kind of right now, as we're saying goodbye, I expect, people are going to start dropping off, and that's cool. So if you're leaving, I will see you guys tomorrow night. But just in the meantime, I'll just kind of glance through the chat briefly. Okay. Kaysen's crazy for that one. Do you recommend studying any Tuesday before the exam? I do. I think that you should relax. I think that it's a good time for review videos. So if you haven't already, I have a speed review video, which actually, if you check out the description, I have links to like the review videos. One, I have it's 50 minutes, like 50 of the whole course. And that one's kind of detailed. So that's a great video to look at like today, tomorrow. On Tuesday morning, I have an ultimate speed review video. I can't believe I talked as fast as I did in that video. If you put it at 2x speed, your ears might explode. But I talk very fast. I do all of AP Gov in 14 minutes. It's absolutely insane. But yeah, I would recommend some light, easy studying. Nothing that's going to be too stressful. But, everybody's different. If you are completely unprepared and you have just started studying 20 minutes ago, then yeah, you might need to study Tuesday morning. And you'll just, take a nap at 3 p.m. after the AP exam. Appreciate it, Celia. Again, anybody else, any shout outs, anything like that? Shout out to Mr. Gold. I'm friends with Heimler. That's a good guy. Got his number on my phone. We collabed like 4 or 5 years ago. He's a good dude. He just needs to remember the little people. Once upon a time, we both were very little YouTube channels. We both had like 1,000 subs, and he blew up. You guys know that though. I'm doing okay, but he's doing incredibly well. Ben Truong's goated. I don't know how to say his last name. I feel bad for that. Hi, Mr. Scarborough. Mr. Lowe. Yeah, this is long. Yeah, don't be too stressed about the FRQ, especially the essay. We're going to talk about that tomorrow. But Blue Dragon, I will tell you right now, it's not a real essay. And they actually score the essay nicer than the other 3 FRQs. So the essay is low-key actually kind of easy. As long as you don't get too stressed and crash out, like you'll be good. So don't worry about that. Deja, don't cry, please. Dejala, don't cry. We're going to be good. No tears. We're good. We're good. Green Bike Lane School wants us to go to school before the AP exam. I don't believe in that nonsense. Every school is different. You got to follow the rules, but they will let you in the school. You should get there at like 11 a.m., maybe 10:45 a.m. So you get there because they're going to bring you in the testing room, I'm sure, by 11:15, 11:30. Get there, relax, make sure you have everything you need. Remember, you can have paper. So even though it's a digital exam, you can have paper. So if you want to like make a little outline before you do your FRQs, you're allowed to do that. So make sure that you have that your administrators know that and they, respect your rights during this test. Shout out to Mrs. Gibson. I did get Mr. Scarborough already. Ben Truong for the 19th time. Ms. Smith, Mrs. Carr, Mr. Birch, Mr. Vicari. All right, Mr. Altman. Thank you, Karina. I appreciate you. She asked, "Where's that one?" It's in the description. But yeah, it's called Speed Review. You'll find it. It's 13 or 14 minutes. All right, that's it for this one. I'm gonna get out of here because now we're just dragging on. I will see you guys tomorrow, 6 p.m. for Unit 5, 8 p.m. for the FRQs. You're gonna do amazing. Again, if you're heading over to Heimler's chat or Heimler's live at 7 p.m., tell people about me. I appreciate it. Thank you so much for anything that you do for me. I really couldn't say thank you enough. So again, I will see you guys soon. Until next time, you already know, but this has been a LaMoney production. Thanks, guys. See ya.